There we go. I think we've got it. Yes. Okay, cool. All right, everything's running. Welcome back, everybody. I hope everybody had a great Thanksgiving weekend. We do have, I forget if I've mentioned, because I'm running two of these, I forget if I've mentioned for this group, our soft deadline is the 13th. Our hope is to have a full final, not final, but a full draft to put into policy language and all that by that point. And that's just for the qualification standards. We're not touching the performance standards yet.
Do you mean by like next
Yep.
Friday?
Yep. Yeah. Yes, I do.
Because this group of attorneys that you have circled are not overworked and underpaid, especially around the holidays.
And OPDS never gets anything out that quickly, let's be real. So
I'm just going to say that this is the
you.
timeline that we've been given.
So we're going to talk about that being an aspirational timeline, like
Sure.
all of our standards are aspirational.
All right, so that said, I do want to dive in. Last week we did a lot of work fleshing out what some of the options might be for dependency. My hope was that we've had some time to firm up some of those choices. I think we've got based on what we have for dependency, I think TPR is in a good spot because we set a pretty solid standard for dependency. And I think the consensus we reached was once you've got a really good grasp of dependency, TPR is less difficult to conceptualize and less difficult to step into. So my hope is that we can firm up the dependency standards today, get all of that finished, not finished and finalized, but in a solid spot. And then one more meeting, hopefully next week, to handle the adoption standards. So before we get going, what questions do folk have? Brilliant. All right, let's move on then. Dawn, thank you very much for the notes that you sent in. I think there's a lot of really good notes in here. So my immediate thing, just going from the start of those notes, when I used the word adjudications here, I did mean jurisdictional hearings, dependency, but there's no explicit requirement that it be that. What are folks' thoughts on what kind of litigation experience we would consider part of trial practice? For dependency, like you're handling everything at least up until a permanency hearing standards.
I think trial attorneys, misdemeanor at least. I mean, I think what's important is people have experience having a client and having the ability to advocate and maybe knowing some rules of evidence, albeit they don't apply in the permanency hearing. So I would.
Yet, I would like to say yet on that.
So what I'm looking at, and I want to recognize that historically we have tied qualifications to qualification levels in the criminal realm. I think we want to step away from that as a hard and fast rule because that we have a lot of folk who come into dependency day one, right? And we want to have other ways to support them demonstrating competency without having to be certified on a completely separate field that they're not involved in, right? Like I did criminal work before starting dependency, but other attorneys at UVPD definitely didn't. Like they stepped. Yeah. Go ahead.
I feel like just specifically saying the number of contested adjudications, that's prohibiting so many people from actually being able to join and have a caseload. So many things don't end up being contested. I mean, we've got people waiting to be part of a contested TPR, for example. Everyone thinks it's going to go and then settles day up. I mean, we all have that experience. And so I feel like the number of contested doesn't really capture what we're asking for. And so that's why,
Well,
you know, maybe the number of observed, I don't
I
know.
think I think if the goal is to know that you are or we are offering, and Kevin, I think you're referring to that little like Dawn's thoughts when I
Yeah,
put that comment in about we should look at other hearings. So my
yeah.
thoughts are this. These are for sole practitioners just starting out, the baseline, not like the most experienced lawyer. What you really want to make sure is someone, a frontline litigator of that advocates for human beings, has you want them walking into the courtroom with some experience of having a contested, go to the line, eye to eye, toe to toe. I'm not saying be mean or nasty in the hearing, but know what it's like to litigate something, to have played soccer, right? Because if you don't, the client, that you don't know that they have skills for cross examination, which is an art form, right?
Right.
Or evidence rules, or how to interview your client to get the story that you're going to tell. But it doesn't necessarily mean that they need to have experienced activity in a contested jurisdictional adjudication. It means they have had to litigate something. Tying it to misdemeanors where there's jury trials, I think that's not necessary. But in my comment, kind of like, let's look at the other ways people litigate. People stand toe to toe and say, I disagree with you, and you're just going to have to prove your case.
And I
And
like
I've
that.
got some skill.
I think that fits the idea that we're going for is to open up the ways to show this experience. I know, and Tara, I know you weren't here last week when we discussed this a little bit, but my thought on this particular piece is trial practice is trial practice regardless of content area. It's that litigation experience. And this would be an area where, say, somebody who was a prosecutor or a former DOJ attorney might be able to satisfy this component. But if they've never had they've never represented an individual client, and maybe we care about it being an individual, maybe it's okay if it's an institutional client, but they've never had an actual client, they would not satisfy the metrics for client communication, right? So they have some of the skills, but not the others that we would want to see in somebody handling a dependency case solo, if that makes sense. So,
I think we also need to make room for people with domestic relations experience.
Yeah.
Two of my really good hires had very little. They had done like prosecution clinic or something as a law student, but they had tried a bunch of domestic relations, and that, brought them to what Dawn's talking about, of having to advocate for a client, sometimes a client that wasn't particularly easy to talk to or have really reasonably held beliefs at the moment. And I think that that's another place we should look at, allowing people to show expertise.
Okay. So if we were to say something like jury or bench trials and or contested motions hearings, would that be sufficient? Is that something that we feel like we can quantify, or is there some other language we might want to use here?
Well, I know other people have had their hands up, so I think we should really ask them. And then when they're done, I just have something about maybe even an institution lawyer can be benefit. So,
Yeah.
but I think we should defer to the people who've had their hands up.
Go ahead, Holly.
Well, and I really, at this point, I'm probably going to say what Karen just said and what Tara just said, which is I'm going to say that my very first cases tried had nothing to do with criminal law, nothing to do with dependency. I did complex litigation with experienced lawyers in a law firm for sexual harassment, litigation, torts. I mean, I did complex litigation with mother revoking her consent on a private adoption. Like, I did a whole bunch of those before I ever tried a case to a jury in a criminal matter. And I did a bunch of custody cases before I ever did any of that kind of work. So that's why it's always kind of been an irritant to me that there was this criminal pathway only sort of, and I've never understood that, because I frankly think my skill set was better than the lawyers who had done a misdemeanor jury trial. I mean, having done depositions, having to read like psych evals, having to talk to experts. I mean, you don't do a lot of that in a random like harassment, DUI, or what have you. So I definitely think, and the other thing, Kevin, I wanted to make sure, these are like ors,
Yes.
right? And we talked about
Yep.
that at the last meeting, is, these are all ors. So it's like you can do A, B, C, or D. It doesn't have to be like you have to do all of. When you had like some of the, I think that watching the adjudicated hearings, because again, like I think to Tara's point, like we rarely have those. Like we're not going to have a whole bunch that lawyers are going to be able to sit through, 5 of them and then be qualified, because it could take 5 years to get through watching 5 adjudicated hearings. So.
And that's the idea, is like we currently have the other experience route for qualification for a lot of things. And this is a way for us to more formalize what that other experience should look like. What do we want? Because the criminal side of things is it's not a one-to-one. Not everybody, like that's not going to always transfer over. So what are we looking for, and how do we quantify that in a way that we can not that there's not going to be gray area, because there's always going to be gray area, right? But this at least gives us more of a framework that we can look at for most of the decisions that we'd make. Vicky?
I think along with everyone else, I came to this from Domrel. I mean, I was in Wallowa County and not much call to do a ton of litigating in such a tiny county, but I did custody matters, I did domestic relations matters, I did divorces and modifications, and I came to dependency that way. And so I think as long as they've got some solid adversarial type situations, even in an administrative capacity, if they're doing contested adversarial administrative hearings, as long as they have a client that they're advocating for and presenting evidence on behalf of, I think we need to be able, especially if we're trying to bring in additional attorneys to this type of work, we have to find other paths where somebody could say, yeah, I've only ever done Domrel, but I could do dependency work if I can brush up on the dependency specific case law and statutes and rules. I could take what I know and transition it to that type of litigation.
And that, for me, I agree with everything that's been said, but I've had some really incredible dependency attorneys that came from the Department of Justice and the DA's office. And so something about having a particular client versus institution, I don't want to do that. Maybe they're not called institutions. Maybe they're called agencies. Nonetheless, I don't think it needs to just be like a private practitioner. I feel that we can really have value with the prosecution side coming over, because they know so many of the internal rules.
And I
I'm
don't disagree.
Disagree with you, Tara.
I must have misunderstood you. I'm sorry, Kevin.
No, you're good.
I do think that I think there is a difference. So I think my worst hires have been from the DA's office personally, in that they have never had a human client. DOJ, they represent caseworkers in a way. And so maybe they've had that more. But I do think, to get to what sort of Dawn was saying earlier, just like that, having the client counseling experience of preparing for a hearing, whether it's a half an hour contested hearing or a 3-day hearing, that's critical. And I think actually just in general, coming from a criminal background doesn't always really get you there any better than a domestic relations, where usually you've been hand holding and listening to a lot of really emotional stuff. Whereas criminal cases, it's such a narrow thing that you're representing somebody on. Or if you're in the DA's office, you don't really have a human. So I think we do need to have something that gets at the, have you worked with a person in crisis and like been able to, create a narrative or, and advocacy around their needs.
And that one of the things that you said, Karen, that I did want to make sure that I actually do believe there's a lot of value that comes from DOJ attorneys who've represented the agency. They do have an idea of what a client is, although it may not be as nuanced as private or defense bar attorneys have. It's still representation. It still makes sense. DAs, on the other hand, whole different ball game. No, but like some of them may have some experience representing clients from well before, but just the fact of having been a DA, somebody whose only experience has been a DA, that would be somewhere where we'd want to look in and say, and that has been some of our practice when DAs do come over and start defense work is we look at their qualifications a little bit more and want them to have the support of either a firm or a really close-knit consortia to work with them on the how do you actually represent a client side of things. So that's where some of this is coming from. Dawn? Oh, you're muted.
Read the comment, but I'm watching you type in and you're typing in providing litigation representation, and my comment says a little bit more detailed, but I think someone needs to have litigated something in some type of formal setting, not like just preparing for it or talking to people about it, but literally I went in the courtroom and I litigated that visitation or that FAPA or that or what that contract was supposed to say or that motion to suppress.
Okay, so you're not just saying like you have to litigate the jurisdictional trial or the TPR trial, but just you're saying litigate something.
Some kind of hearing, like my little comment said, like some kind of frontline courtroom litigation experience. They were in a courtroom or an I've done administrative hearings that aren't really in what we think of as courtrooms, and they litigated it. That kind of actual experience, but it should be broader than just an adjudication of a dependency case.
Okay, so let me get rid of these two lines because I think it's covered here. So we're looking at trials, contested motions, depositions, or administrative hearings. Is there anything else that we feel would fit in here, or do we have a specific amount of what we're looking at? I mean, somebody who's been through one or two contested trials has a lot more experience than somebody who's only handed one, say, motion to suppress hearing. Unless it was a really strong motion, like a really heavily contested motion to suppress hearing.
You could put something in there that says, you could do one or two hearings, but you could have gone to a very good comprehensive litigation skills training like the National Criminal Defense Lawyers Macon Conference, which is 2 weeks of you standing up and over and over again doing cross-examination, direct examination over and over for 2 weeks all day long. And that could get you there.
And that's that is down on the 2 as the alternative.
Okay, gotcha.
Instead of doing these hearings, we do want to provide people the opportunity to attend a training that we would certify to say, yep, we think you have the skills to satisfy this.
Okay, gotcha.
Could we maybe add a 3 and hear me out on this, or just maybe like experience, like somebody could vouch, like a different lawyer can say, this person's been with me, they've seen this, they've prepped this, they've had these meetings, like something that could account for experience in a mentee type spot.
Yeah. So we do there's and to give you again, I apologize, Tara, some of this is stuff we've discussed previously. The current what we anticipate is the direction that's headed is pulling some of the Massachusetts model that where there are supervising attorneys regionally to help with new entrants to public defense, and that would absolutely be something that we'd be using as part of this. Whether and yeah, trial practice, training or mentorship, both would work. My thought is that if somebody's in a mentorship program, the trial practice is going to be something that will occur as a part of that mentorship program. So they may satisfy both criteria at the same time. But the way
So Kevin, I mentor
Yeah.
lawyers in Clackamas County, for example, that are part of my firm, and I sit in on trials with them. And whether I do first chair or take the lead or let them take the lead and just sit with them, I let them decide how they feel about it. And depending on how complex the issue is, they let me know. Is that the kind of thing you have in mind?
I mean, ultimately, I think that is kind of where we would hope things go. I don't know because I'm not positive where the development of that program is going to sit right now. So all I know is that that's a framework that that has been talked about as a direction that we're headed. And it is one that works in Massachusetts. So Jennifer?
Yeah, I think that's great. I'll make my plug again that people who are providing mentorship should be getting some sort of credit in their contracts, as I said before. But I mean, I think the other part of it, I know that we're focused on kind of the solo practitioner, but I think the mentorship is also important for organizations like Dawn and I are in, where that is a fun, I mean, that's how most of, so I think it's important that we include that and that it's clear that that is a way that you get qualified to do it independently.
And one of the things to note is that the way it's currently, the current draft that we have is that for any of the parts that folk don't independently qualify for, they'll be submitting they'd be working with a mentor and would have a plan on how to address those components of the certification that are missing, right? So if somebody has a lot of, let's say somebody did a lot of not frontline litigation work, but they worked for like a PI firm and did a lot of the behind the scenes client management and working with experts and all that sort of stuff. So they have a lot of client communication experience. They have a lot of working with experts experience. They know how to interview. They know how to do all of these various things, but they've never seen a courtroom. Then that would be the only thing that they need to work with a mentor on, right? We don't need them to do a whole bunch of work on stuff that they already have good skills in. I'm not saying that that's necessarily a person who exists. I don't know. I chose the career that I chose. So, but in any case, are there other pieces that we want to add or refine about trial practice specifically?
Well, when I look at my notes, I'm trying to see A1 trial practice contested. It looks like you took out something I had a question or a concern about, which was that half FTE piece.
Yeah.
Yeah.
So the way we currently measure experience in our current standards is by time and number of years. And one of the problems with that is that not everybody is full-time. So 1 year doing a certain type of casework is not the same amount of actually doing casework for the same for different people. If you're only a half FTE, you're getting half the experience in a year that someone else is who is a full FTE. I mean, loosely, right? Like,
yeah, I disagree because they're either they're half time doing something else, possibly, right?
right.
And so I don't want half a lawyer just because the lawyer that gets assigned to me chooses to only have a half FTE contract with the commission, right?
Yeah.
Because so they shouldn't get a lower standard of what they need to show.
No.
To
That's
be
not
certified. Yeah.
I'm saying the flip side, right? If we had set a stand, and the reason I removed it is because I think what I'm hearing from everyone is we've got something more defined and more usable than time, which is kind of what we were going for. Is time's just a terrible measure. It doesn't do a good job of showing experience or skill work. So we have another option that we can use. But if we do use time, it's an inverse relationship. The lower your FTE, the more time it will take you to meet the standard.
Yeah.
That's what I was going for, is if you're a half-time attorney and our standard is 1 year, if you're a half FTE, that's 2 years for you. Which maybe there's a way to manage that a little bit differently. But if we're not using time at all, then there's no need to prorate for FTE. So but that was that to address that question. Okay.
Kevin, I have a question on.
Yeah.
I don't see on this, and I don't have the other sheet. I don't have it in front of me, but I'm thinking co-counsel. Like, what if somebody was like third chair on a? Do we want to address at all someone who maybe wasn't the primary, or add anything about like I mean, I guess it's sort of like mentorship, but like a third chair on a hearing and did cross-examination of a witness or handled some of the things, or is that kind of getting too deep in the weeds?
I think that's a great question. What does everybody else think?
I think that falls under mentorship, or like the mentorship component. It's one of the things you could say. I was mentored. For example, I third chaired and prepared the cross-examination, but I sat in the courtroom for the entire hearing.
I think that's important, but I really like what Rebecca said in the chat. I'm hoping everyone saw that. Each county and each judge are so different. So anyone that's going to be before, a certain judge, I feel like they need to have some mentorship, whether it's a meeting or what have you, that just says, this is what this judge expects. I have 14 or 16 now in Marion County, and literally they are all different.
But
when Dawn picked up a case, Dawn's been doing this for a bazillion years. Well, maybe not that old, but she's been doing this for a long time. And when she came out to Clackamas County, she reached out and said, "What are your rules? What do I need to know?"
Yeah.
Even an experienced attorney needs to do that.
Is that an OP? Is that a commission certification thing? Or come on, are you or are you a professional lawyer? Like I think, right, you know what I'm saying? Like I went to that courthouse to understand the security, the layout of the courtroom. I went and met with the clerk there and asked if there was any tips she could give me. I went and had lunch and spent about an hour and a half figuring out where I was going to meet my client. That's kind of different from being certified. If that comes later, if you give someone a contract and then you're asking them to go to other counties and you find out they're showing up and they haven't done any advance work, you're like, maybe we don't continue your contract.
Keep in mind that later on we'll be working on performance standards, and what I'm hearing is that's more a performance standard issue than a qualification. Like these are the things we need you to be able to do to just assign you cases. But there's other work too, right? Like in order to be effective, here's the other stuff we need you to be aware of and adhere to. Okay.
So I think what Annie said, like I don't know if I think it's part of a mentorship. Like if you were a co-counsel or, in a trial, I think you've done a trial. If you've co-counseled and you took a witness and cross-examined or whatever, maybe you didn't do every witness, but even when I have, even when I'm mentoring and I've got my you know, baby lawyers, for lack of a better word, with me, if they're taking a witness, a lot of the times, I mean, they've reviewed the discovery, they know what's going on. There's many times when I'm like, who's this again? I'm sitting at counsel table, I'm like, who's this again? You know, because I'm more experienced and I haven't, you know, I don't have to do as much prep work. They often do more prep work than I do. And so I would say that if they have that would fall under trial practice. That's my 2 cents.
And I'm wondering, as I'm thinking of this more from my having evaluated the AQs and how often some people are very literal and some people are very on reading things, and some people are kind of like throw shit at a wall. Excuse my language. I forgot this is recorded. And so I guess maybe it can be something even under trial practice, number of contested hearings. We could even just include something like may include being co-counsel or third chair if taking on some of the roles or some language around that, just so folks who are more literal in reading these understand that experience, they can include that experience for us to evaluate.
And that may be like, it may be that I have no idea. We may have a companion document that helps explain some of this. I'm not positive whether that's, we'll see, right? Like knowing where the intent lies, I think we can craft some of this because this outline is not the qualification standards, right? It's in short form, so I know what to draft when we do the ultimate policy language. And this is, you know, knowing where the work group's like thought process is, and then run through the language. And then my hope is that I would be able to get a copy of the full draft to everybody to comment on before anything gets submitted to the commission.
And so one of those, that's great, Kevin. Of course, we want that. I don't know a way to say this, but like, how much time maybe would we have? I mean, sometimes things coming from your office, or you were all last minute and you got to reply by 5 o'clock, and I might be in a trial. And when that happens, then I don't feel that we are submitting a collaborative, best worked product. So, I mean, hopefully we would have 1 work day or 2 work days to
I
review.
will endeavor to give everyone as much time as I can.
Thank you.
Okay, so do we feel like this is a good spot? Do we have a number that we want to throw in for a number of contested hearings? I heard a 2 earlier.
Say between 3. If we have changed this down to contested hearings instead of adjudications, which are an all-day affair, right? A contested hearing could be 2 hours. I propose somewhere between 3 and 5. You have done something contested. Maybe you were a certified law student and you did something contested, and that would count.
How about bench or jury trials count for double? And then we can set something like 4, right?
Yeah.
If we say it's 4, everything other than a bench trial, anything other than a full trial counts for 1 of those 4. Each trial you do counts for 2.
Right. That's a reasonable middle ground. And if we find out the lawyers have no idea what a courtroom's like, we can change it later.
Fair enough. And I mean, these aren't going to be set in like rock hard stone. Like there will be periodic review of these to see if there are tweaks that need to be made. Hopefully, on a much better cycle than it's been 5 years. And that was just when I forget what we added. KO knows, but we added like one thing in 2019. I think it had something to do with waiver. That was it. Other than that, nothing's changed on these for a very long time. So hopefully this will be more regularly reviewed. Okay. How about client communication?
I think my comment was the big comment I had there was, I think we need to add something that you have some training or experience in developmentally appropriate interviewing. i.e. interviewing children, that could be by an expansion or clarification in item 2, I realize.
And that was my thought, was diminished capacity would include diminished because of age.
Well, there, maybe we could clarify that, or
I want to know-
developmentally appropriate interview skill, because a child's capacity isn't really diminished, it's just different, right? Their communication styles different, not diminished.
But I
They
think
could
it's
be more
important.
intelligent.
You know, we did that presentation this May or whatever it was on representing, I'm not going to say the title right. I'm not doing well on it, but representing parents who have disabilities. Like, how do we represent the parent, and how do we know how to interview or get the collateral sources to know that this parent is suffering from some disability? And that interview is very, very hard. But we never know when a mom or a dad we get. And I'm going to say, as a state, we have statutes that tell us what to do, and we presented that at the conference. But my own practice, let alone my county, and I've seen other counties, I still do not think we are holding agencies' feet to the fire in representing parents that have disabilities, because we are not identifying them. And I think that is based on lack of interview training. So I don't think it should just be age.
I also
No,
feel like it should almost be more open-ended, of like, describe the experience that you've had working and role as an advocate for people with diverse backgrounds, interests, and capabilities or something. I mean, it feels like it should be more than just like, I've interviewed 4 clients or, whatever. It feels like it should be more like up to them to sort of be able to articulate, like, yeah, I worked with, I mean, it didn't necessarily have to be in a trial setting. It could be, I volunteered at a battered women's shelter and I, interviewed people there. And then, I mean, I think there could be a variety of things, but it feels like, just to put this in numbers, I feel like it's such an important part that it has to be more fleshed out than just, how many hours or times you've done it.
Okay, so there are different ways that we can approve, I guess it would be the right word, the whether someone meets a certain qualification component. We could certainly pose this as a narrative question. Just fundamentally, what we're hoping is to develop an online form for people to use, where they only have to answer questions that are relevant to the qualifications that they're actually asking for. So that should hopefully make the qualification process easier for people to do. So that could be it. We want a sufficient explanation. The more squishy we make this, the more concerned I become about the introduction of bias from the people reviewing the answers. The more hard and firm of a standard that there is, the less likely that gets introduced. But this may be one of those situations where we need to get a little looser, because it's hard. This is an area that's hard to quantify.
So Kevin, I just have a quick question based on what you said, and maybe I didn't hear you right, so I just want to clarify. You're saying that they only have to fill out for whatever area they want to work with, for example. And so I just want to make sure, or I want to determine whether or not we've come to an agreement on whether or not we're letting people represent only children or only parents. I think Dawn and I felt strongly that you're a better attorney if you do all parents and children. And as the administrator in Clackamas County, I won't take people on who, as attorneys on the contract, that say, I only want to represent children,
Right.
for that reason. But I don't know what OPDC's policy is, or whether or not we're going to be addressing that in any way. I just wanted to get some clarification.
So my notes from the last session are that we concluded against separating child and parent representation standards. I think I remember asking a vote on that one, and it was, I think it was unanimous.
I think it might have been. I think we all probably feel, I know Dawn and I were like getting, all right, am I going to have to come out there and bring some, well, I'm going to do some some hiney kicking. It's being recorded. But I just wanted to make sure. I didn't recall. Thank you, Kevin.
Yep, no, you're good. That was kind of one of those fundamental questions that needed to be answered. So, okay. Other comments on the client communication piece? Then let's go ahead and set this as it is for now. And if we need to review it, we can come back, but I'm good with that answer. Working with experts. I know, Dawn, you had a couple of notes on this piece as well. I'm fairly sure that we would have, well, I don't want to say I'm fairly sure. My hope is that we would have some solid trainings on how to use OPDC's systems once those systems change.
I think that was just my demonstrate an understanding of how to do it, or that you've accessed a training. It seems like there could be some trainings on that are you use those trainings, you review some sample. I mean, we could make mock samples, right?
Oh yeah,
as part of a training, and demonstrate an understanding. I think my comment kind of set it off. And then
ideally, the training that I've had in mind, there's at least some amount of time spent during the hands-on work where you have a client file, and one of the things you're going to have to do is ask for an expert to assist you on some issue.
I think the point I was trying to make is that instead of saying that review PAE request, get rid of one of the two of those and then just incorporate something that said demonstrate some kind of understanding of the process, and have a training that includes reviewing samples of the
they were definitely going for, what I had listed here is definitely going for two different purposes. I want to know that people are using PAE, or at least that they know how, which is different from knowing how to use the expert once you have one.
Okay, I guess I'm a little confused. Okay, so under.
Oh no, I see what you're saying. Hold on.
So under complete a training or mentorship, training and mentorship in what? Filling out a PAE or working with experts?
Yeah.
Okay, because
that's what I
meant.
Sorry. Yeah. And court record review. So you've got the two components. Do you know how to get one, and do you know how to use one?
Okay.
How to get one is we'll check.
I think it just needs to be more clear. I agree with you, Kevin, because maybe even just breaking it up to two issues. One is like, how do you get the expert? That would be C. And then D would be, how do you work with the expert?
Oh, okay. That makes sense.
Yeah, because I was talking about threatening to make Eric Dietrich look at my face to get something approved, which is different than actually working with the expert once I get it approved.
So I think the first part, though, that's hard is finding the expert. And I wonder to what extent we can incorporate something around a training on sort of finding experts. I've got an email folder where every time somebody's recommended an expert, I throw in, but I think that's one of the things I see. I mean, certainly it's all over the pond constantly, or the juvenile law list.
Breaking it into three then. Find an expert, pay for an expert, and then how you use the expert.
I like finding funding, yeah. Nice.
How do we quantify finding? I guess, training.
Why don't you just say utilizing experts? So have utilizing experts, and then you're as C, you want to make sure they know how to utilize experts.
Oh,
What the
as the
law
title,
is,
as the title
yeah.
under C. Yeah, I got
And
you.
then the big components are under the big components of utilizing experts is understanding how to obtain funding for indigent and how to work with them. I mean,
I still think number one should be finding. I mean, it is so hard. And I agree with Jennifer, like all the experts, we just throw them in a file. I mean, maybe one day OPDC can streamline, like, just keep an outline and we could ask OPDC, who are the
but
experts
is
pay
that
for?
is that a core requirement for having these cases? I mean, it's a kind of investigation, right? So, and we don't have anything here that requires us to demonstrate that we understand how to investigate allegations and prepare to confront them,
No,
right?
no, but I think it's different than that, Don. I think so because, that is inherent in when we're asking, have you observed or have you litigated or been co-counsel? But none of that is actually letting people, know like there are experts, so find them. And so if somebody's seeing that, find them and be like, yeah, how do we find them? I think then there'll be more of an inquiry. I don't think it hurts.
So maybe we can come back to the specifics on how we want people to demonstrate this, but Vicky, go ahead. You're muted.
I think the issue is issue spotting. It's being able to review the records that you're being given and to be able to identify if there is an issue for which the expertise of an expert, the knowledge and experience of an expert would be helpful, either in helping you understand the issue or helping explain it to your judge. Because sometimes I'll get an expert to help me review medical records so I understand what I'm up against, but I don't necessarily need them to testify at the hearing. I need them to walk me through what my defenses are, what my arguments are, what my theory should be. And then there are other times where I absolutely need them, a psych expert, a SUD expert, or something where I need them to testify at a hearing. So it's issue spotting. It's being able to having utilized experts understand what they're good for and under what circumstances. As for the PAEs, I don't even fill them out. I have an assistant. I've had an assistant for the last 25 years that I've been a public defender, and they fill the forms out. I couldn't fill one out today unless I had to look at it because my staff does. So I don't think that that's a criteria. We're not going to hire you unless you know how to fill out the form. I think that might be a performance measure, but I would disagree that it's a requirement to exclude somebody. I think the bigger issue is being able to look at 500 pages of discovery in a hotly contested dependency and decide, do you need an SUD expert? Do you need a shrink? Do you need a psychosexual? Do you need a neuropsych? Do you need an investigator? Do you need whatever it is to be able to see the issues? And then in terms of finding people, OCDLA's got the expert database. I mean, there's resources out there, colleagues and such. So I don't know that that's a criteria that would exclude somebody that we want to have as a criteria before somebody can become a dependency practitioner. I think that might be a performance thing down the line. But I think it's that they can, it's just issue spotting. Can they spot the issues? Can they know who could help them to better understand the issues or better present the issues?
I will note, I actually have the same question that Holly put in chat, which is, with regards to issue spotting, we have a trial practice litigation experience qualification piece. Is that sufficient here? Do we? I kind of like, I'm swayed about the funding piece. That does seem more like a performance standard than a qualification standard. I'm swayed that direction. I could be swayed back if somebody else has a great option or a great argument otherwise. And not finding, issue spotting may be part of that other piece. Holly, go ahead.
I mean, I feel like we're getting really into the weeds, and I keep going back to their qualification standards. I mean, and so the things that we've already listed up above, like you're saying, and what Vicky was saying, I think are true in that if I'm already, have sufficient litigation experience, I have the experience on how to deal with an expert. I don't, I think you need to put it in there that they need that the lawyer needs to review, but PAE, whatever. But I just feel like, I mean, are we going to say you have to read and write? Like, I feel like we're getting down to that level. And so
Yeah.
it's like you graduated from law school. You're already qualified to be a lawyer. So,
Right.
Yeah.
So, okay. So if I'm remembering right, when I put this in here, review of PAE requests and review of court records were intended to capture, is this person utilizing experts? Like, can I check and see that they do have experience in using them? Either they, clearly they know that they can use experts because they've told us they need one. And I can
Right.
check court records and say, clearly they've used experts, because here's some cases that they've handled where they secured an expert witness who produced a report for the court. So those things are ways that we could check and say, yes, we recognize this person has used experts. So that's a way we can quantify that they meet this, that we know they know what they're doing on this. So if we break that back down, if finding them and funding them are not really qualifications, but more performance standards, then I guess we could just get rid of this part too, because now we've just got the one. So we can look internally to see, have you used them? And that's one way you can qualify.
Right.
A training or mentorship program would also suffice. Is there another way that someone can demonstrate that they're familiar with and able to use experts?
They could take a quick little test and read a paragraph and say, what you could literally take a test.
Yeah.
Here's a paragraph, read it and give us what types of experts might you want to investigate, use, and why.
And that then covers the issue spotting that we all agree with.
Right. A very
I mean,
short
I
test.
and I'm fine. You can take out finding. I mean, I can issue spot, and my people can issue spot, and they know what they might need. But it is still the challenge to figure out who and who's still accepted, and the finding part. But if that's not appropriate to be in this document, then that can just be a matter later.
Okay. Holly, you have your hand up. I don't know if it's still up or, okay, cool. All right. I added project management because I know somebody said the words. It was a thought. I'm not married to the idea of project management being a qualification.
Well,
Maybe it's
Go ahead. I slapped it down hard after I researched what a project manager was, because I know someone who has a certificate in it that at Standard Insurance. And I think maybe you might want some good skills and organization and moving things forward, but it is definitely not project management as it is routinely understood.
So flip side is the concept of project management, just the ability to move those projects forward. Is that more a performance standard than it is a qualification standard? Yeah. Okay, cool. Let's get rid of it then. One less thing to worry about. Motivational interviewing. I will note that this is a hot topic right now, but I have not had any formal motivational interviewing training. And so if I am wrong about what this is, that's okay. Tell me that I'm wrong.
Maybe we should just watch the video of Chris Farley on Saturday Night Live, the Down by the River, that motivational speaking. Like, I don't even know what this is getting at, to be honest. I really don't.
I put it in my comment, explained I don't, motivational interviewing is a therapeutic counseling technique.
Okay.
And it is, I think it's more, so you want to demonstrate a skill or training in client interviewing skills and approaches that are trauma informed. Like, I think trauma informed interviewing skills are more important to a litigating lawyer than motivational interviewing. Motivational interviewing might be a case of the social worker's skill or the therapist that DHS helps our client find skill, but not, it should not be a qualification for being a lawyer.
Okay. Is that a consensus, Jennifer?
I agree with Don. I also think that this is part of client communication. I think it's sort of all wrapped into one. And I feel like motivational interviewing really had its moment of everybody talking about it. And then we moved on to like trauma informed. I worry a little bit about, I think being trauma informed is important. What I worry about is unless there is some way, like, what does that mean? DHS, I'm reminded that we're on camera, recorded. DHS uses this all the time. Like, they think if they just say it. And so, like, how does someone demonstrate that they're being trauma informed in their client communication? Obviously, I think it's important. I'm not saying it's not.
Jennifer, I think we should have a CLE on it. Like they should have demonstrate some CLE credit and that's what I think we could, because it's objective. And I think it is so necessary. And I don't think many people and many agencies don't actually understand trauma informed, even though they preach it, because you get for example, a tribal member, and you step on their property and they all of a sudden they're angry and confrontational and they're out of control and we have to take their kids. But if we're really trauma informed, we know that all of their intergenerational trauma, that's a normal response, that kind of thing. And so I feel like our practitioners, and if we're really trying to figure out what we want in our people, then I would like them to have CLE training on trauma informed.
I think that would be fantastic. I don't know that it's available right now. So, like, I don't know that you can go and tell me if I'm wrong and I'm just missing. Like, can somebody go find a CLE on trauma informed communication with their clients?
I feel like there's one, but if not, all of us are part of a ton of other organizations, maybe OCDLA or the bar. We need to just make that a priority to create it.
Yeah.
And then people can check it out.
So two things. Number one, it is 6 o'clock, just as a heads up on where we are with time. Number two, I think there actually is one. If I'm remembering right, like 3 years ago at the Juvenile Law Conference, 3 or 4 years ago, there was an ethics credit that was about how following the Oregon rules of professional conduct actually demonstrates trauma-informed communication, because it provides a safe space for your client to be who they are and give you the info. Anyway, so you're right. I think there are CLEs on this. I think we can find, like, all the things aside, hopefully we will have the option to create some or certify ones that other people have created. So before we go any further, because it is 6, I just want to check in. What folks' thoughts are on time and whether anybody needs to leave. Go ahead.
Oh, I have to leave. I have a family obligation at 7 that I have to get to.
Okay, no worries. Thank you, Dawn. Alternatively, we're close. I think we're really close on this. So if we can get through D, and check whether there's any other things that we want to add, or I think we're close to a good stopping point, but if we have to stop now, we can. So Holly, your hand was up
Yeah,
earlier.
I wanted to say, I don't think it needs to be a CLE. So, I mean, I just went to All Rise the last 2 years for our family treatment court. We had tons of options on trauma-informed communication. Mandy Davis at Portland State, I've done an all-day training with her. It's not a CLE thing. You know, it was all of our entire county, DHS, lawyers, CRB, CASA, whatever. So I think there's lots out there that you can do that. I would just say, like, I think it needs to say something around that you have knowledge and training around trauma-informed communication. And really, it's more than communication, because when you take a Mandy, I don't know if you guys have taken anything with Mandy Davis, but I mean, it's everything from when you walk to the door of your office and how your office should be set up to be trauma-informed. It's not just your communication style. So,
Vicky.
I know, because Kevin, you were trying to push us through. I want to do away with D, because I don't know about you guys. I'm in a really small community, and my treatment providers change daily. I mean, we at one time had 4 substance use providers. We have 1 now. And at any given time, we have 1 parent trainer in Deschutes County that we maybe can access. We have 1 person offering ISRA services, and then that person lost their contract. We had to have another person. I don't think that we can, that's a more of a performance standard than saying we're not going to allow you to take dependency cases unless you can espouse and list off from memory all your current treatment providers. I think it would be better that they could, as with the experts, be able to identify the issue. What does your client need, youth or adult? What does your client need, and what kind of services are available? And if they aren't available in your community, how would you access them? In the same way, identifying those issues that an expert can help you on. It's the same idea, but I don't know that that would preclude somebody just because they couldn't spout off the top of their head who provides the best substance use disorder services in their county. I don't think that would preclude them from representing kids or parents.
Okay.
I agree, but I think leaving something in there about, like, you know, what have you, I don't know, like, demonstrated proficiency in identifying appropriate treatment resources for clients or something, because I agree that knowing which ones are that's a proficiency or, you know, something down the line. But I think that we do want to make sure that people are, like, aware that that's part of their job, is helping clients navigate a variety of agencies, not just DHS, but also who they get referred to. So I think that we should leave it in there, but not like, can you list the top 3 or whatever, but more of, are you familiar with the type of treatment resources that clients will be referred to, and, you know, staying abreast of.
Yeah, it's just written, the caption, the header for 2 says possesses experience in the following skills. And I don't know that experience with local treatment providers is a skill. That's knowledge. So, and I agree, but it's more like being able to meet with your clients in your trauma-informed setting, get a sense of what their background and what services could benefit them. Do they need housing assistance and what's available? Do they need transportation? Are you aware that DHS can pay their bill to fix the tires on their car if transportation's an impediment? You know, those sort of things. Do they need parent training? Do they need parent mentoring? Do they need hands-on training with a child that has a particular medical device that they need to be trained to use because DHS is claiming that they don't know how? I mean, but that's going to be very specific to your case. And again, it's just more issue spotting, which again ties back to the idea of what's your trial practice and what do you have experience in. So I don't know how we quantify it.
And don't the national, like, when some of those other standards from other states have just some language that say you have, like, knowledge, right? That's all it says. Like, it doesn't, there's nothing beyond that. So
So we could fold that into partly into performance standards. We could expand, because number one is that, like, my thought is that that's the what knowledge do you have section. And so if we move that, maybe change the language up here, instead of reviewed and familiar with current versions of documents, we can say, we can put, I can massage some language in there and deal with treatment provider or treatment community, knowledge of local treatment community options.
Well, it's not just local though, Kevin. I mean, I've had to reach
Yeah.
far afield. I've had to have specialists, you know, argue to my, when I have a parent of a child that has ASD, and I'm trying to argue that they've got to bring in specialists to train my parents how to care for that child. If you're claiming that you're removing the child because parents don't have the skills, you best bring in somebody to give them the skills. And little old Crook County doesn't have anybody like that. So it's, you know, so I don't know that local is the test. I think it's really a key of, are you familiar with the issues that are going to come up in these type of dependency cases, and then what services and skills and supports can you throw at them in order to ameliorate the problems?
And that's some of the soft skill work that's hard to quantify, right? Because what we're looking for is people who can do that issue spotting, and also how to connect that to advocacy for your client. And looking through this, there's one other thing that I realized I had been thinking about but did not put on the list of skills, which is the other soft skill part of meetings with the agency, where you're acting in a role that's less litigious and more mediation and negotiation, and trying to resolve issues. And that's not, I don't know that that's necessarily explicitly trial practice. I don't know that it's not included in trial practice. I mean, there's some of that work is trial practice, but it's also, I mean, that's why I stopped doing criminal work, is because I loved the soft skill work more. It was more interesting. So, okay. So I'm going to move the knowledge of treatment stuff up into section 1 for knowledge. I'm not sure this is a good stopping point, but it is a stopping point. How is everybody feeling about that? Yeah. Okay. Okay. So I know that folk were it was helpful for folk to have something to work on between. So 2 things I would hope we can come back for the next session. Again, adoption would be great to have something to put on paper. But the other piece, if there are ways that we can conceptualize those other soft skills, something we can put in as a measure for non-litigious work as an attorney.
Kevin, when you're talking about adoption, what are you talking? I mean, what?
So there is a constitutional right to a parent having an attorney when they oppose the adoption of their child by a private party. So there is a provision in the statute for public defense to you know, when the court issues the show cause why the adoption should not proceed.
Like a step parent adoption, for example, that I got one of those. It was
my
a step parent adoption, and dad was in prison, and I got appointed to represent dad. So it wasn't a DHS case.
My mom's an adoption attorney, so I'm familiar.
Yeah.
Okay.
So those cases.
We don't do them. I mean, we've never, 25 years of this, I've never been appointed in one.
I've had 3 of them.
I mean, we get called
That's
like
crazy.
every couple years.
That's crazy. I don't think our consortium, I've been in 2 consortiums for 25 years, and nobody has ever been brought in on a contested private adoption.
The flip side of that is I think that the courts may not necessarily all be aware that that right exists.
I think
that
you're correct.
Yeah. So, and they may be dispensing with consent unconstitutionally. So,
Well, we're aware because the case law that started that came out of Josephine County. So we're aware and we get assigned. So.
Yeah, now that I think about it, the ones that were assigned were just straight from the bench. I don't think it came from open. I think Judge Darling just gave him to me. I got a bone to pick with her. Okay.
The one
of
that
them
I-
was not fun. So
the one that
okay.
I did, the parent that we represented had a criminal case, and brought it to the court's attention, and the court was like, "Oh, well, you all can do this." Nobody in our firm had done one before, but it
So
seemed
what
like
about
fun.
the adoptions? Like my firm completes the adoptions when adoption is approved as the plan and the termination happens, and then the adoptive resource. But I don't think that's through OPDC.
Mm-mm.
That's
No,
a different
that's paid.
contract.
Yeah, that's paid for by DHS.
Okay, all right, that's a different contract. Okay.
Yep, not our gig. Okay, so let's, when we meet next, and it's likely next week, soft skills and adoption. Okay, have a great night, everybody. Thank you for sticking around a little bit late, and I'll see you guys hopefully next week.
Have a good
Thanks,
night, all.
Kevin. Bye.